arguments the following: a party cannot challenge the constitutionality of a law that imposes an allegedly unconstitutional restriction on the exercise of a right if the party could have very easily satisfied the preconditions for the exercise of the right.
I think we would probably say that, but I don't think it is necessary for the court to go that far to resolve the case in this.
How can that possibly be the law? Suppose a state university says that no person of a particular race may enter any of the university buildings unless that person pauses for 2 seconds, stands still for 2 seconds before entering the building. Would you say, well, you can't challenge that racial restriction because it's no big deal to pause for 2 seconds before you go into the building?
I mean, the court in a case like that might say, in the context of race discrimination, that the mere fact of being subject to racially disparate treatment is injury in fact, regardless of whether any other concrete consequence comes of that. And the court has said, for example—
Do you think that's limited to an unconstitutional instance of racial discrimination? It wouldn't apply to the other, to free speech rights?
Well, it's certainly true in general that in order to establish standing, a plaintiff has to allege and then show not just a deprivation of a legal right, but some practical injury. But
no newspaper may run an editorial criticizing the president unless it's in a particular font?
I guess the reason I would say that the court doesn't need to address those more difficult hypotheticals is that at least in order to challenge a limitation like that, the newspaper would have to allege, were it not for this restriction, we would use a different font. What makes this case particularly easy in our view is that appellees could have avoided their injury by doing precisely the thing that they would have done if the statute and regulation were not on the books.
Let me give you one more example. A town passes an ordinance that has 2 sections. Section 1 says no newspaper may run an editorial criticizing the mayor except as provided in Section 2. Section 2 says any editorial criticizing the mayor must be published within, criticizing a speech made by the mayor must be published within 20 days after the speech. Would the newspaper, after the 20 days passed, have standing to challenge Section 1 or only Section 2?
I'm sorry, could you?
Yeah, okay, it's a little complicated. So, town passes an ordinance. Section 1, no newspaper may run an editorial criticizing any speech delivered by the mayor except as provided in Section 2. Section 2, any editorial criticizing a speech delivered by the mayor must be published within 20 days after the mayor's speech. Can the newspaper, after the 20 days have passed, challenge Section 1 or only Section 2?
Well, I think they could probably challenge both, but they would have to say, were it not for this legal restriction, we would publish an editorial critical of the mayor after 20 days.
Where does this